The Voting Rights Act of 1965 was landmark legislation that aimed to end racial discrimination in voting. But as our Robert Costa tells us, the power of that law has been challenged in recent days, causing turmoil just ahead of this fall's midterm elections.
And every family across this great entire searching land will live stronger in liberty, will live more splendid in expectation, and will be prouder to be American because of the act that you have passed that I will sign today.
Nearly 61 years ago, President Lyndon Johnson signed the Voting Rights Act, a defining moment for the civil rights movement and a turning point for the nation.
Slavery is abolished in 1865. In 1870, the 15th Amendment is passed, intending to guarantee black men the right to vote. 1920, the 19th Amendment is intended to guarantee all women the right to vote. And still, black Americans are kept from the polls in too many places, by law, by intimidation, by violence. So one thing we can say about 1965 is that people have been waiting a very long time.
Waiting and struggling to end racial discrimination in voting, says Martha Jones, a history professor at Johns Hopkins University.
Lives were lost, lives were threatened, communities were under siege, and Americans, black and white, put themselves in harm's way in order to finally set fire to the feet of Lyndon Johnson, set fire to the feet of Congress, and finally the result is a Voting Rights Act. But to think of the Voting Rights Act as an act of Congress, right, or an act of Johnson's pen is to, in essence, erase the blood from the page. And there is a lot of blood in that story.
That story continues. Late last month, the Supreme Court ruled it was illegal for lawmakers in Louisiana to create a new majority black congressional district. The 6-3 decision, split along ideological lines, has enormous implications for who will wield power, and it will make it far more difficult for districts drawn on racial lines to survive.
Let's be clear. Once the Supreme Court rules, it's a final judgment of the highest court of the land.
This past week, Congressman Cleo Fields of Louisiana, a Democrat whose district will be affected, sounded the alarm.
The real issue is whether or not a person who looks like me will have the opportunity to serve in Congress. And that's what that fight has always been about.
The Supreme Court's decision was the culmination of years of rulings made by the conservative majority under Chief Justice John Roberts, saying race-conscious policies in education, the workplace, and in voting are unconstitutional.
From a conservative perspective, what does this decision mean, not only in terms of the law, but for American democracy?
I think this is one of a series of, frankly, good decisions by the court that is saying racial discrimination is wrong.
But many black Americans I've spoken to in the South, they say they don't see how this is played out as racial discrimination, but an ability to have representation.
Yeah, well, I think they're taking the wrong view of that.
Hans von Spakovsky is a veteran conservative lawyer appointed to the Federal Election Commission by President George W. Bush. Von Spakovsky's views are aligned with the recent majority opinion written by Justice Samuel Alito, which says that using race to draw election maps is unnecessary and unconstitutional, but that using politics to do so is just fine.
That's part of what the Supreme Court has called the hurly-burly of politics.
What is the hurly-burly of politics?
The hurly-burly of politics is that we have basically an open market where people compete with what their ideas should be. But anybody who thinks we're ever going to get gerrymandering, partisan gerrymandering entirely out, that's just not going to happen. We've had it since Elbridge Gerry, the governor in Massachusetts, did it in the early 1800s. That's where the name for it comes from.
And in the wake of the ruling, many Republican-controlled states are rushing to change their maps this year and give the GOP which holds a narrow majority in the U.S. House, a better shot at keeping it in November. This past Thursday, amid outrage and protests, Tennessee's Republican governor signed a new map into law that critics fear will dilute the voting power of the state's black citizens.
What happens if a consequence of this decision is fewer black members of Congress?
Well, if they want to get someone elected, look, if they affiliate with the Republican Party, black candidates will get elected. We've seen that.
So they have to become a Republican in some of these red states to have a chance of winning?
The point of our Constitution and the Voting Rights Act is that everyone is guaranteed an equal opportunity to vote. They are not guaranteed success in the candidates that they think should be elected.
In terms of the arc of the Roberts Court, where does this decision fit?
Well, I believe that this decision represents the complete collapse of the Roberts Court into partisan political activity.
Congressman Jamie Raskin, a Maryland Democrat, is the ranking member of the House Judiciary Committee.
There's no other way for me to understand what just happened other than they too are trying to bail out Donald Trump from all of his policy catastrophes of this term by making it possible for him to win districts.
They would deny that,
Sure.
surely, because they've been rolling back the Voting Rights Act for years.
Yeah. In fact, if you understand what they've done, they've basically said it's unconstitutional to deliberately create a majority African American and majority Hispanic district, although you can create all the majority white districts you want. That's just considered the norm.
You are both a constitutional law professor and a House Democrat. When you evaluate this ruling, do you just see the Supreme Court acting in a conservative way?
No, it's got nothing to do with conservatism. It's about partisan determination to give Donald Trump and the GOP a majority the best they can.
You believe that's the court's intent?
Absolutely. No doubt in my mind.
What gives you that belief and evidence of it?
Because there's no other way of explaining these decisions that are not rooted in the text of the Constitution, much less the Voting Rights Act. They totally reverse the plain meaning of the Voting Rights Act. And they are rushing these things to get done before the elections.
As the Supreme Court's decision roils this year's elections, Professor Martha Jones says it is the latest chapter in America's ongoing reckoning with race and the Constitution.
As a historian, my counsel to judges is that history will be the judge, right? That history will be the judge. That part of what we're doing in this moment is making a record, and that's part of what the Supreme Court does for us, is make a record of what has happened here. Only history will tell us, in some sense, what it meant, what its long-term consequences were for Black Americans, yes, but for American democracy. I think anyone who is a party to what is unfolding at the court now is wise to be humbled because they won't always control the narrative, but history writers will.